because they've made political contributions. But separately, to me here, the big case, regardless, is that I'm no lawyer, but I know the Supreme Court has held over and over again, the police can't hold you for more than 5 days without, basically charging you. So they're violating habeas corpus here, are they not?
That's right, and that's the case that's up before the Supreme Court. But let me get through the background to show you how we get to that case. So what happened is that these supervisors voted on the EIR, but the law in California, a case called Break Zone Billiards versus the City of Torrance, says that if a supervisor gets paid greater than $500 in a campaign contribution within 12 months of a vote, he can neither advocate for the developer nor can he vote on the particular project.
He must recuse.
He must recuse, exactly. Well, Kanabi and Antonovich both advocated and voted on the project. Now, there were 4 votes, so 2 of them were illegal, which meant that the EIR, the vote on the EIR, was illegal. I came in and I sued to stop that EIR in the court. And we came in front of Judge Yaffe. Now, what happened is that Judge Yaffe is getting this $46,000 from the county. There's a bribe. So you know what happens. It turns out that Judge Yaffe allows the thing to go through. Now, during the course of this case, we have another thing that happens. We have the state bar making me inactive. And the side part of that is that the judges had gone to the state bar to try and get me disbarred and be inactive because I had brought the same type of case against the judges back in 2002, saying that these payments violated the California Constitution and the due process clause of the U.S. Constitution. So the judges went to the state bar.
And did you win that previous case? Did you win that previous case?
So it was dismissed on jurisdictional grounds in the federal court. However, in 2008, the California Court of Appeals held that these payments were illegal and your phone may be monitored.
Start over, because again, our friend is a political prisoner in jail, Richard Fine, right now, so they keep popping in with the call may be monitored. Now, go back. So you had the California Court of Appeals rule in favor of you.
Court of Appeals.
Because you were citing another ruling. Please continue.
Okay. The California Court of Appeals held in 2008 in a case called Sturgeon versus the County of Los Angeles that the payments by L.A. County to the judges violated Article 6, Section 19 of the California Constitution. And that was the exact thing that I claimed in my 2002 case. So what the state bar was doing to me was violating what the California Court of Appeals was holding to be true.
Let me stop you again. I mean, that's cities are chartered under the state constitution through the counties. The power comes from the state and the elected legislature. This is ass backwards, as they say, where L.A. County is trying to absorb and take the judges literally under its control. But Sacramento's not concerned about that. The Court of Appeals was and ruled for you, because then didn't they quietly pass a law, if I read this right, giving immunity to these judges?
You're absolutely right. What happened is that after the Sturgeon decision came down, what the state did is that the state legislature passed a law saying that they gave retroactive immunity to the supervisors and the judges from criminal prosecution, civil liability, and administrative and disciplinary action. So because they knew that these people had done wrong, and the criminal part of it was misappropriation of funds.
Okay, we're running out of time, so finish up with what happened to you. We're running out of time, Mr. Fine. Finish up with what happened to you, and then now your year-plus incarceration, and they won't even tell the media why you're there. They just say that's where he stays now.
Yeah. So what happened is that I left the case in 2007. In 2008, Judge Yaffe ordered me to pay money to the county without any notice to me. I was gone from this case in October of 2007. In January 2008, Judge Yaffe orders me to pay money to the county because I filed the paper 1 day late. The county had filed their papers 60 days late. He did nothing to the county, and he orders me to pay money to the county without any notice to me, without my being present at the hearing. And I came in and I said, Judge, you can't do that because, number one, you're violating the Constitution, but number two, you know, you're getting payments from the county. And now Yaffe had not disclosed at this point.
Your call may be monitored or recorded.
Yaffe had not disclosed that he was getting payments from the county. And the county had not disclosed that they knew that the EIR was illegal. And nor had Epstein disclosed that he knew that it was illegal. I then got Yaffe to admit on the record at a court hearing that he was getting these payments. And then I disqualified Yaffe, and Yaffe refused to leave the case. And then Yaffe ordered me to make the payment, to disclose my assets, to have that order enforced. And I refused to do that. Then Yaffe had a contempt hearing, at which point, in the contempt hearing, I got Yaffe to testify as the first witness. I got him to testify that he was receiving the payments, that he was not disclosing the payments.
I mean, he should instantly, hold on, he should instantly recuse himself. Federal, state law, I mean, all of the precedent says he must recuse himself. He's a witness in the courtroom when he's the judge. I mean, this is insanity.
Truly, it's not only insanity, it violates every Supreme Court precedent. And you have the Supreme Court precedents of In re Murchison that says a judge can't judge his own actions. You have the precedent of Offutt versus the United States that says that a judge can't take a bribe. And
well, that's like the Secretary of State in Kentucky with the State Ethics Board ruling he can run his own election against Rand Paul for Senate in Kentucky, never before done, and so he runs his own election.
Yeah. I mean, it is total insanity. I mean, this judge is ending up taking a bribe, and then he's judging his own actions of taking the bribe. And every U.S. Supreme Court precedent is against that. So, anyway, so the end result of it is that Yaffe holds me in contempt for not answering, saying that I have to, holds me in contempt and throws me in jail under coercive confinement, saying that I have to stay in jail until I tell what my assets are so that they can enforce this false judgment against me to go out and take my assets.
So now, via a civil judgment, no jury, no nothing, you're in jail more than a year. This is a dangerous precedent if it's allowed to stand. And we know the Supreme Court earlier in the year, you've had some of the other justices refuse it, but now Ginsburg is accepting it.
I'm sorry, you got blocked out. You said the Supreme Court earlier in the year.
Well, I've read over the case, but tell me if I'm right. Wasn't it Justice Stevens, or which one is it that early?
Justice Kennedy earlier in the year denied my application, and then I went to Justice Ginsburg, and Justice Ginsburg was the one.
Your call may be monitored or recorded.
All right, so tell us what's going to
go into the conference.
Sure. So we're running out of time. So tell us, Mr. Funk, the show's almost over here, and we appreciate you joining us from prison, from your political dungeon. So what's happened in jail? I mean, if the Supreme Court says no, I guess you'll live out the rest of the 10, 15, 20 years there, and the taxpayers will pay for it, and a new precedent's set. Judges can say, put Alex in jail, just put Bob in jail, put Carol in jail, just put the Pope in jail, put anybody in jail, just dungeons, just goodbye. I mean, do we do whatever we want?
That could be the case. So it's really up to the Supreme Court to follow their precedents and basically set me free. That's where we're sitting at. Now, one of the things I do want to mention before we close out is that there's going to be a rally for me on Tuesday, the 20th of April, at the L.A. County Courthouse, which is at 111 North Hill Street in Los Angeles. And it's going to start at 7:30 in the morning when the judges come in to park their cars. And it's going to be continuing until 12:30. And there'll be speeches and things about 11 o'clock in the morning.
And there's also one coming up at the Supreme Court, and we went over that 2 hours ago when we had Leslie Dutton on, and people can find out all the details at fulldisclosure.net. But, sir, in the video interview I've seen, I mean, go back over. This is why we went to war against the British. in 1775-76. It's in the Declaration of Independence as the list of abuses, the exact same stuff that's being done to you. Talk about how, I mean, as a lawyer, as a former federal investigator, what this is like for people that don't understand the law.
Well, I'm sorry. They broke you off right after the word talk. Give it to me again.
Well, you talked about the parallels between this and the Declaration of Independence and how big a deal this is.
Well, the big deal is that it's the exact parallel, because when you go to the last part of the Declaration of Independence and you read that last part, that talks about the fact that the king controls all the judges in the court. And therefore, there was absolutely no way that anyone in the colonies had any opportunity to get any fairness in the judicial system in England.